I am your host this morning. My name is Stacy Arzeta. And again, just to remind everybody, we are live streaming. I'm going to start today with a brief introduction of each individual in the courtroom, all of the students. So as I call out your role, please introduce yourself with your full name, your team code, and if you are a witness, your character name. And scores, again, you can add this information onto your score sheet. So first, we're going to start with the prosecution opening. Please introduce yourself to the judges and the score. Whoever from Team Pac-Man is handling the opening, you can just introduce yourself. You can unmute and you can turn on your video if you want.
Good morning. I'm Sophie Harrison. I'll be directing Kyle Kuzak, crossing Taylor Perkins, and giving the prosecution opening statement.
Thank you. And for the defense, who will be handling the opening?
Good morning. My name is Rudy Polanco. I'm part of Team Fortnite. I will be doing the opening statement and doing the cross-examination and doing the direct examination on Professor Van Owen.
Great. And for the defense, or let me do the, sorry, I'm just going to go through the prosecution. Who is your second attorney?
I am our first attorney. I believe that Ms. Harrison will be going second.
Okay, and just say your name and what roles you will be doing.
Good morning, Your Honor, members of the jury, and opposing counsel. My name is Kellen Hansen. I will be delivering the closing statement, performing the direct for Detective Jordan Markowitz, and crossing Avery Becker.
And the next prosecution attorney?
Hello. Good morning. I am Jake Garcia on the Pac-Man team. I will be directing Alexey Fuentes and crossing Professor Blake Van Owen.
And the prosecution timekeeper?
Good morning. My name is Camille, and I will be timing.
Great. And for the defense, let's do we did the opening, let's do the defense closing.
Good morning. My name is Alexa Henry. I will be direct examining Avery Becker, cross-examining Kyle Kuzak, and doing the closing statement.
And the next defense counsel number.
Good morning. My name is Adriana Petrucci, and I will be direct examining Taylor Perkins and crossing Alexi Fuentes.
And the next defense attorney.
Sorry, I believe that was all of our attorneys.
Oh, okay, great, thank you. Yes. And can we have the prosecution first witness?
Good morning, Your Honor, members of the jury, opposing counsel. I am Ana Sophia of the Pac-Man team, and I will be portraying Jordan Markowitz.
And prosecution witness number 2.
Morning. My name is Lola Cheney of the Pac-Man team, and I will be portraying Alexi Fuentes.
And prosecution witness number 3.
Good morning. My name is Bella Hoba, and I will be portraying Kyle Kuzak.
And defense witness number 1.
My name is Tristan Penninger, and I will be playing Avery Becker.
Great. Defense witness number 2.
Hi, my name is Chloe Casola, and I will be playing Blake Van Owen for the Fortnite team.
And defense witness number 3.
Hello, my name is Nate Barrio, and I'm on the Fortnite team, and I will be portraying Taylor Perkins.
And can we have the defense timekeeper introduce yourself?
Hi, I'm Calista Cobb, and I'll be timekeeping for Fortnite.
Okay, is there anybody that I missed? Sorry, I got a little off on my list here. Is anybody did not have a chance to introduce themselves?
Might I make a note of clarification?
Sure.
We got a bit out of order there. So Miss Cheney will be our third witness, our third witness. Miss Bella Hobaugh will be our second witness, playing Kyle Kutzak.
Great.
Our witness order is Jordan Markowitz, Kyle Kutzak, Alexey Fuentes, just so all the scorers can have the correct order set out at the beginning.
Great, thank you. Okay, so just one more reminder that only the presenting attorneys for the prosecution and the defense and the witness plus the judge should have their camera and microphone on during the tournament. Scorers, you can leave your video on or turn it off that's your discretion. Everyone whose video is not on will be hidden so that they won't be on the screen. Everyone else must keep their camera off and be muted. Timekeepers, you can come on, turn your video on as needed to alert your team to their time left as needed. Again, if you're not performing in this round as an attorney, witness, or timekeeper, you must exit the Zoom now and watch on the live stream. Failure to do so can cause your team to be sanctioned. So the mock trial is now in session. Honorable Judge Vicente Vigil is presiding.
All right, thank you, ladies and gentlemen. And to start off with the swearing in, team members, could you please raise your right hands for me, please? Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of this mock trial competition?
I do.
I do.
I do.
All right, thank you. And witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do.
All right, thank you. And scoring panelists, could you please raise your right hands for me, please? Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of this mock trial competition?
I do.
All right, thank you. And gallery members, since you are appearing remotely, I'm not going to swear you in, but again, I will again ask you to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during this round and during all the remainder of the rounds during this mock trial competition. At this time, the court will call People of the State of Colorado versus Avery Becker. The defendant does appear today with counsel. Prosecution appears today. And from the prosecution, any preliminary matters?
Yes, Your Honor. First of all, we as the prosecution would like to request that we all assume that the witnesses have access to the exhibit packet, if there is, of course, no objection on the part of the defense, just to speed things along. If not, we are prepared to share screens as necessary.
All right, thank you. And from the defense, any response?
No objection, Your Honor.
All right, thank you. We will make that assumption. If there is any problems with any exhibits, we may need to utilize the share screen function, but otherwise I will assume that the parties have all of the documents in the case problem. From the people, anything further?
Yes, Your Honor, if the defense has no objection, would like to request that the timer be paused so that video evidence may be played. This is, of course, a bit of an irregularity, the very appearance of video evidence, and it can take up considerable amounts of time to play it all.
From the defense, any response?
No objection, Your Honor.
All right, thank you. That sounds reasonable to me. We will exclude from any time calculations any delays caused by this unique format that we're utilizing today. And prosecution, anything else?
Yes, finally, we would like to share our screen and examine the stipulated facts and the jury instructions briefly.
And from the defense, any response?
No objection, Your Honor.
All right, thank you. Counselor, that's fine as well.
Sharing screen now, I believe. Is it visible?
Yes, it is, sir.
Okay, so stipulated facts. I'll take a moment for each necessary page. And jury instructions, page 1. If you would like me to move at a faster pace for these, please say so. Your Honor, are you satisfied that the stipulated facts and jury instructions have been made known to the jury?
Yes, thank you, Counselor.
Thank you, Your Honor.
All right, thank you. And from the defense, any preliminary matters, sir?
Yes, Your Honor. We, the defense, ask that witnesses, jurors, and Your Honor have exhibits ready to view at their convenience, and that Your Honor give myself or opposing counsel screen sharing availabilities.
All right, I will do so. I believe the host, I believe you should already have those screen sharing abilities. Just let me know if you intend on doing that for the introduction of any exhibits, and we'll address that in due course. Anything else, Counselor?
One more thing, if we can, the defense also asks if we can also stop the time when video recordings or audio recordings are being played for the jury.
Yes, I will grant that request for both sides, just to make sure that both sides are on the same level playing field. All right, thank you, Counselor.
Thank you.
All right, if there are no further preliminary matters from the people, you may deliver your opening statement. Thank you.
Thank you. May I begin?
Yes, please. Thank you, Counselor.
Today, you are going to hear the story of Mr. Avery Becker, a young man who, up until now, has gotten away with everything. He has been lazy, manipulative, disrespectful, and when all else failed, a vandal and a killer. This must end today. Mr. Becker, a Colorado high school student, was the best student lawyer on his mock trial team. He was head and shoulders above everybody else, but he refused to do his work. This attitude infuriated his mock trial coach, lawyer Mackenzie Brackman, to no end. He tried again and again to get Mr. Becker to work with him. He simply wouldn't. One day, Mr. Brackman had enough of this. He demoted Mr. Becker from their A team to their B team. However, rather than facing the consequences of his actions, Mr. Becker found a loophole. He had his best friend, Mr. Taylor Perkins, drop out of the team just 1 week before regionals, forcing Mr. Brackman's hand and leaving him with no choice but to let Mr. Becker back on the A team. His plan worked. He was able to attend the regional competition and succeeded in winning 2 awards, despite Mr. Brackman's original wishes. Upset that he worked around the consequences rather than facing them, Mr. Brackman chastised Mr. Becker at their next meeting. Mr. Becker was not used to this kind of reaction. He was used to getting away with it, no problem. So, in response, he stormed out of their meeting, grabbing a permanent marker on the way. Once outside, he scrawled all over the hood of Mr. Brackman's prized Porsche with this permanent marker. This was the straw that broke the camel's back for Mr. Brackman. He expelled Mr. Becker from the team, this time permanently. Mr. Becker didn't want to listen once again. He tried reasoning with his teammates. He tried talking to Mr. Brackman again. He even tried visiting his office. Mr. Brackman simply wasn't budging this time. So Mr. Becker began to think, if he couldn't get back on the team, he would make sure Mr. Brackman knew just how unhappy about it he was. So he planned to vandalize Mr. Brackman's home, a plan he even discussed with teammate Alexey Fuentes. Another fit of entitled behavior was in the making. This time, it ended worse than anyone could have imagined. On March 6, 2020, Mr. Becker unlawfully entered Mr. Brackman's home at 444 South Flower Street. Upon entry through the back door of the home, Mr. Becker was surprised by Mr. Brackman, who, in the hopes of defending himself, had taken a knife from his kitchen. There was a scuffle, and in the end, Mr. Becker stabbed Mr. Brackman in the back before fleeing from the scene. Today, you're going to hear from Detective Jordan Markowitz, a crime scene whom, with her cell phone technology expertise, will be able to tell you the whereabouts of Mr. Becker's phone on the day of the crime. Through her cell tower records, you will see that the phone was present at Mr. Brackman's home on that day. You will also hear from Kyle Kuzak, who has 19 years of crime scene reconstruction experience. She has examined the crime scene and all the evidence collected there, and will be able to paint a vivid picture of the sequence of events on that day. Finally, you will hear from Alexey Fuentes, a peer and even a friend of Mr. Becker's. She will be able to tell you about Mr. Becker's behavior on the mock trial team, as well as his original plans to vandalize Mr. Brackman's home. Therefore, by the end of the day, you will be sure beyond a reasonable doubt that Mr. Becker unlawfully and knowingly entered and remained in Mr. Brackman's home with the intent to commit criminal mischief, and that during the furtherance of that crime, Mr. Brackman's death occurred. Therefore, you can be sure beyond a reasonable doubt that Mr. Becker is guilty of murder in the first degree and of second-degree burglary. Thank you.
Thank you, Counselor. And does the defense wish to present an opening statement at this time?
Yes, Your Honor.
All right, thank you, Counselor. Go ahead when you're ready.
May it please the court, counsel, and ladies and gentlemen of the jury. Today, you are going to hear about a case that has no face and no case. My name is Rudy Polanco on behalf of Avery Becker. Today, you are going to hear a murder investigation that was clearly rushed and used potentially false evidence, and a detective that states that Avery is guilty, even though you couldn't see the intruder. In this case, you're going to hear about one of the most heinous crimes a human can commit, the murder of Mackenzie Brockman. Ladies and gentlemen of the jury, make no mistake, this was a plain and simple murder, but by who? The Ring doorbell security system caught an unknown person entering the property that was covered in a full face mask, wearing gloves, and a gray and black long sleeve jacket. There are no crucial identifying features on the suspect. If there is no face, then there cannot be a case. Next, you are going to hear about the prosecution's expert witness, a faulty detective who rushed this investigation and corrupted evidence under his leadership. Detective Markowitz is a homicide detective who jumped to conclusions about who the real perpetrator was and lost critical evidence. Detective Markowitz relies on Ring security footage. As you will come to learn, you cannot see this person's face or any identifiable features. No face, no case. Now we are going to hear from Kyle Kuzak. Kyle Kuzak is a certified crime scene reconstructor investigator. Mr. Kuzak needed more physical evidence to make a better report. Cusack states that there is no cast-off blood spatter until the knife was pulled out of the victim. You will come to learn that Mr. Cusack would have found this piece of evidence helpful to determine exactly where the victim was stabbed, but the evidence was lost by the detective. Next, we are going to hear from the prosecution's final witness, Alexey Fuentes. Alex is a senior at Colorado High School and a member of the mock trial team with Avery Becker. You will come to learn how Alex falsified evidence in a murder trial. You will also hear how Mr. Fuentes' witness testimony showed a clear pattern of jealousy towards Avery Becker. And Mr. Fuentes was always having to work twice as hard than Avery. Now we will move on to the defense witnesses. You are going to hear that the defendant, Avery Becker, did have a vendetta against Coach Brockman. Coach Brockman kicked Avery off the team because he came unprepared to mock trial practice. Avery was obviously mad about this as he won the Best Attorney Award and mock trial came naturally to him. In retaliation, Avery did write some words on Coach Brockman's car, which he is extremely apologetic and regretful for. The question is, was Avery so mad that he can kill another human being? The next witness is Taylor Perkins. Taylor is a freshman at CU Boulder, and Taylor was on the mock trial team with Avery Becker as they were close friends. Taylor was with Avery the day of the murder, and they spent the entire day looking for Avery's lost phone. They looked for the phone everywhere, up and down, and Taylor remembered that they were at the Fry Shack. They burned the entire day looking for the phone and went to the Fry Shack as the afternoon crew got in. It was there at the Fry Shack that Perkins and Avery found out that Coach Brockman has been murdered. The defense's final witness is Professor Blake Van Owen. Professor Van Owen is a private investigator and former police officer with the Denver Police Department. Along with being a private investigator, the professor is also a teacher at CU Denver on police practices and social justice. Ladies and gentlemen of the jury, Your Honor, and opposing counsel, you will come to learn that Professor Van Owen stated that this investigation was clearly rushed. The problem with a rushed investigation is that it can lead to serious doubts on who committed the crime. We will also hear how Professor Blake Van Owen has significant doubts that Avery killed Coach Brockman. So who committed this murder? You're going to hear about Blair Rollins. You will hear that Blair Rollins had a better motive to kill Coach Brockman as the coach lost the case against Blair's dad. You will hear that people would say that Blair would be the person capable enough to kill someone. Professor Van Owen dug deeper than the detective and pulled yearbook photos of Avery and Blair Rollins. He concluded that Avery had a very similar body type, and if placed back to back, you wouldn't be able to tell the difference. The professor's final conclusion is that he believes that this investigation was rushed, and Blair Rollins had a better motive to kill Coach Brockman than Avery did. Ladies and gentlemen of the jury, you need to consider the facts, which are the prosecution has a faulty detective who lost critical evidence and rushed this investigation, falsified evidence, and surveillance video where you cannot see the intruder's face. So consider this, ladies and gentlemen. If you cannot see a case, then how can there be a case? It is clear that the prosecution will not meet their expectation of proving their case beyond a reasonable doubt. Ladies and gentlemen, we the defense ask that you, the jury, come back up with a verdict of not guilty and not put an innocent person in prison.
All right, thank you, Counselor. At this time, the prosecution may call its first witness.
The prosecution calls Detective Jordan Markowitz to the witness stand.
All right, thank you. Detective Markowitz, can you raise your right hand for me, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. Detective, Counselor, go ahead and begin when you're ready.
Please state your name and spell your last for the record.
Jordan Markowitz, Markowitz.
Detective Markowitz, what is your profession?
I'm a detective with the Denver Police Force.
How long have you been a detective?
7 years. I've been with the force for 13.
Do you have a specialty as a detective?
Yes, I specialize in cell phone technology and forensic data recovery.
And do you have special training for this?
I do. I received a certificate in this field from the American Academy of Law Enforcement following a training course.
Do you often use this training?
Yes, all the time. I've downloaded the contents of over 100 cell phones and used it in over 50 cases.
Your Honor, I move to enter Jordan Markowitz as an expert in criminal forensics and in cellular phone detail records.
All right, thank you. From the defense, any response, please?
No, Your Honor. No objection.
All right, thank you. I will accept without objection Detective Markowitz as an expert in the fields proffered. Counselor, go ahead.
Detective Markowitz, were you familiar with Mackenzie Brackman?
I was. I've had the displeasure of being cross-examined by him on a number of occasions.
And will Mr. Brackman be cross-examining you ever again?
Unfortunately not. He's now deceased.
Why do you know of this?
I was assigned to investigate his murder.
How did your investigation begin?
Well, a passing motorist called 911, and we had a team look into it. I was called to the scene shortly thereafter.
What did you see when you arrived on the crime scene?
Mr. Brackman was lying face down in a puddle of his own blood, just inside the doorway of his home.
And for clarity, where did this happen exactly?
Just inside the doorway, front hall.
And on what day did this happen?
I reported there March 7th.
Detective Markowitz, do you have the witness packet before you?
I do, yes.
Do you recognize what has been previously marked for identification as Exhibit 1?
I do, yes.
What is Exhibit 1?
Exhibit 1 is a photograph of Mr. Brackman as he appeared on that day.
Was it taken by your forensics team?
It was, yes.
And is it a fair and accurate representation of Mr. Brackman at that time?
It is, yes.
Your Honor, I move to enter Exhibit 1 into evidence.
All right, thank you. Defense, any response?
No objection at this time, Your Honor.
All right, thank you. I will accept Exhibit 1, I believe you said, Counselor, is that right?
Yes, Your Honor.
I will accept Exhibit 1 into evidence. Counselor, go ahead.
And Detective Markowitz, what are exhibits? Are you familiar with what exhibits 2, 3, and 4 are?
Yes, those are all additional images of Mr. Brackman taken from different angles.
And they were likewise taken by your forensics team?
They were, yes.
Are they fair and accurate representations?
Yes.
Your Honor, I move to enter Exhibits 2, 3, and 4 into evidence.
2, 3, and 4. Any response from the defense?
Yes, Your Honor, this I object to. This is more prejudicial than probative towards the jury.
All right, thank you. And from the prosecution, any response to that objection?
Your Honor, these are images from the crime scenes, from the crime scene at different angles. They have basically no prejudicial value and they have potential probative value. So that objection does not hold weight.
And from the defense, any further reply to that objection?
Yes, Your Honor, we believe that the opposing counsel's first exhibit that was entered is sufficient enough for the jury to see what happened at the crime scene, and that allowing any more exhibits of Ms. Coach Brockman will be more prejudicial to them than probative, as it will allow them to see, it holds more of an emotional strength.
All right, thank you. The court will overrule the objection, and I will admit Peoples 2, 3, and 4 into evidence. Counselor, go ahead and proceed.
Thank you, Your Honor. Detective Markowitz, or may the jury have a moment to examine the exhibit packets if they have them?
Yes, go ahead, Counselor.
Now proceeding. Detective Markowitz, do you recognize what has been previously marked for identification as Exhibits 5 and 6?
Yes, I do.
What are Exhibits 5 and 6?
Exhibits 5 and 6. Exhibit 5 is the knife that we found at the scene, as it appeared at the scene. And Exhibit 6 is the same knife held up for reference.
And where did you find the knife?
Nearby Mr. Brackman.
And were these photos also taken by your forensics team?
They were.
And are they fair and accurate representations of that knife?
They are.
Your Honor, I move to enter Exhibits 5 and 6 into evidence.
All right, thank you. From the defense, any objection?
No objection, Your Honor.
All right, the court will accept and admit into evidence People's Exhibit 5 and 6. Counselor, go ahead.
And Detective Markowitz, do you recognize what has been previously marked for identification as Exhibit 7?
Exhibit 7, yes.
What is Exhibit 7 for the jury?
Exhibit 7 is a open knife drawer, which I saw at the scene.
Was the picture likewise taken by your forensics team?
It was.
And is it a fair and accurate representation?
Yes.
Your Honor, I move to enter Exhibit 7 into evidence.
All right, thank you. Any objection to People 7?
No objection, Your Honor.
All right, thank you. The court will admit People 7 into evidence. Counselor, go ahead and continue.
Detective Markowitz, did your colleagues document the crime scene?
Could you repeat the question, please?
Did your colleagues document the crime scene?
They did, yes.
Did all of that documentation survive?
No, unfortunately.
What happened?
A few of the photographs of blood spatter which they had taken were somehow corrupted, and so we no longer have access to them.
Were you able to recover them at
No.
all? Were they essential in any way to your case?
No.
Thank you. Moving on. Detective Markowitz, did you find any other evidence related to Mr. Brackman's home?
Yes, I found several Ring doorbell security cameras and was able to access Mr. Brackman's account and passwords to find footage.
How did you access Mr. Brackman's files?
I utilized the Celebrite system to download his account information.
How many videos did you find?
4.
And what did these Ring records show?
The first video was of an intruder walking up to Mr. Brackman's doorway. The next video was the same individual walking around the gate. The third video was that same individual entering Mr. Brackman's home through the back door. And the last video was the same individual running out through the door.
And did you identify the same cameras outside his home?
We did, yes.
Detective Markowitz, were you the custodian of these videos while they were in police custody?
I was, yes.
And are you familiar with the exhibit packet before you?
Yes.
Do you know what Exhibit 10 is?
Yes, Exhibit 10 is the video of the intruder entering Mr. Brackman's home.
Is this one of the Ring video? Is this one of the Ring videos you copied from his phone?
Yes.
Is it a fair and accurate representation of that video?
To my knowledge, it is, yes.
Your Honor, I move to enter Exhibit 10 into evidence.
All right, thank you. Any objection to People's 10?
No objection, Your Honor.
All right, thank you. The court will admit into evidence People's Exhibit 10. Counselor, go ahead.
Your Honor, I request that this time we be allowed to pause time so that the jury may review this video evidence. I will share screen.
All right, thank you. Go ahead and publish the video to the jury, please. Thank you.
Thank you, Your Honor. Detective Markowitz, are you familiar with what Exhibits 11, 12, and 13 are?
Yes, those are the other 3 videos containing respectively the intruder walking around the back of the house, entering through the back door, and then running out through the door.
Are they fair and accurate representations of the videos you copied?
Yes, they are.
Your Honor, I move to enter Exhibits 11, 12, and 13 into evidence.
From the defense, any objection?
Objection to cumulative, Your Honor.
All right, thank you. And from the people, any response, please?
Your Honor, these are different videos. They are by definition not cumulative as they contain entirely separate pieces of information.
All right, thank you. The court will overrule the objection, and I will admit peoples 11, 12, 13 into evidence. Go ahead.
May I again request that the timer be paused while we publish these videos to the jury?
Yes, go ahead, counsel.
Thank you, Your Honor. Just a moment. This is Exhibit 11. This is Exhibit 12. And this is Exhibit 13.
All right, thank you, counselor. Go ahead and proceed.
Detective Markowitz, how did you become aware of Avery Becker?
In the course of my investigation, I decided to look into Mr. Brackman's mock trial team, and I came into contact with Alexey Fuentes, a classmate of Mr. Becker's. It was Alexi Fuentes who directed me to Mr. Becker.
How did you go about investigating Mr. Becker?
Well, I obtained a warrant to search Mr. Becker's phone, but his lawyer informed me that it had been stolen the previous afternoon.
And were you able to acquire Mr. Becker's cell records?
I was, yes.
Detective Markowitz, what do we learn from call detail records?
Call detail records are records of an attempt to connect with a cell phone. So they indicate who was attempting to call a cell phone, where that cell phone was, and when the connection attempt was made.
Detective Markowitz, what did you find in Mr. Becker's call detail records for March 6th?
5 different attempts to connect with his phone, all from Taylor Perkins, at different times throughout the day.
Detective Markowitz, if I may direct your attention to the exhibit packet. Do you recognize Exhibit 15?
Yes. Exhibit 15 is a diagram which I prepared. It depicts the 3 different cell towers to which Mr. Becker's phone connected and the respective ranges of each, shaded in red, as well as a timestamp indicating at what time Mr. Becker's phone attempted to connect with each one.
Does this diagram accurately reflect the call detail records you extracted?
It does, yes.
And does it accurately reflect the geographic locations of the items labeled?
Yes.
Detective Markowitz, what do we learn from Exhibit 15?
If you will direct your attention to the topmost cell tower, the first attempt to connect was made at 12:47 p.m. in an area that surrounds Mr. Becker's home. The second attempt was at 12:55 in an area on the road in between Mr. Becker's home and Mr. Brackman's home. And the bottommost cell tower has 3 different attempts to connect over a period of about 10 minutes and centers on Mr. Brackman's home.
Your Honor, I move to enter Exhibit 15 into evidence.
Any objection?
No objection, Your Honor.
All right, thank you. The court will admit people's, and I'm sorry, counselor, you said 15-1-5?
Yes, Your Honor.
The court will admit people's 15 into evidence. Counselor, go ahead and proceed.
Detective Markowitz, based on your analysis, what conclusion do you form from these call detail records?
Mr. Becker traveled with his phone from his own home to Mr. Brackman's and received several attempts at calls and texts throughout that time.
Detective Markowitz, do you recognize Exhibit 16?
I do, yes.
What is Exhibit 16?
Exhibit 16 is a very similar diagram to the one that I prepared, only In this one, I included a possible pathway, which, based on my analysis, it is likely that Mr. Becker's phone could have taken.
Does this pathway comply with the times at which the contacts were made?
It does, yes.
Is it a fair and accurate representation of the diagram you created?
Yes.
Your Honor, I move to enter Exhibit 16 into evidence.
Any objection to 16?
Yes, Your Honor. Exhibit 16, as the witness stated, portrays speculation.
All right, thank you. And from the people, any response, please?
Your Honor, this is not being proposed as necessarily the actual path that Ms. Becker took. It demonstrates the way in which Ms. Becker might have taken and the possibility that, Mr. Becker did take this path. It shows that it is possible to have done this.
All right, thank you. And from the defense, any reply?
No further reply, Your Honor.
All right, thank you. The court will overrule the objection and admit people 16 into evidence. Counselor, go ahead.
Thank you, Your Honor. Detective Markowitz, did Mr. Becker's phone receive specifically texts?
Yes, in addition to cell phone calls.
How many of the 5 contacts were texts?
3.
Detective Markowitz, based on your years of experience and your expertise, what do you believe occurred on March 6th?
I believe that Mr. Becker drove from his own home past the fry shack near the 1191-1 cell tower to Mr. Brackman's home, where he spent several minutes, broke into Mr. Brackman's home with the intent of vandalizing it, and in the process was interrupted, panicked, and murdered Mr. Brackman in the struggle.
Thank you, Your Honor. No further questions at this time.
All right, thank you. From the defense, any cross-examination, please?
Yes, Your Honor. Good morning, Detective Markowitz. Let's start off with the defendant, Avery Becker. You learned that Avery Becker was kicked off the mock trial team, correct?
I did.
Isn't it true that you also learned that Avery lost her phone on March 5th?
That is what her lawyer informed me, yes.
Okay. Moving on to Alexey Fuentes. Did you interview Mr. Fuentes?
Yes, I did.
In your testimony, you stated that Avery texted Alex, correct?
Yes.
Did Alex bring their phone to the interview?
No, Mr. Cifuentes had left it at home. However, she later sent me screenshots.
Okay. Can I turn everyone's attention to what has been marked as Exhibit 14? Detective, do you recognize this exhibit in front of you?
Yes, Exhibit 14 are the screenshots which Ms. Cifuentes sent me.
And is this a fair and accurate copy of this exhibit?
Yes.
And has it been altered since the last time you saw it?
No, not to my knowledge.
Your Honor, at this time, the defense moves to publish Exhibit 14.
Thank you. Any objection to defense 14?
Objection, Your Honor. The defense established that the exhibit was an accurate reflection of the exhibit, but not that the exhibit was an accurate reflection of the screenshots themselves.
All right, thank you. And from the defense, any response?
Your Honor, Exhibit 14 is just the screenshots of which Mr. Cifuentes sent the detective, and I can lay further foundation if you need to.
I don't think that's necessary, counsel. The court will overrule the objection, and I will admit Defense Exhibit 14 into evidence. Counselor, go ahead.
Did Alex ever bring their phone physically to you?
No.
And you are aware that there's common knowledge that there are apps that can create fake text messages?
Such apps are not, in my knowledge, no.
If you knew there was an app that allowed a user to create fake messages, would this have impacted your investigation?
Perhaps. I expect it might have.
Okay. Moving on to the cell phone tower analysis. You state that the phone pairs to the cell tower with the best signal, correct?
Yes.
Isn't it true that the closest tower might not be the one with the best signal?
Yes, but it usually is.
I'm sorry.
in almost all
I'm sorry,
cases.
Detective. This is just a simple yes or no question.
Objection, Your Honor. This witness has sworn to tell the truth, the whole truth, and nothing but the truth, which is not always contained in a simple yes or no. If the defense would like a more specific answer, the defense should perhaps ask a more specific question.
All right, and Counselor, I am going to overrule that objection. The witness is directed, if you're presented with a yes or no answer, to give a yes or no question, to give a yes or no answer. Counselor from the people, obviously you'll have the opportunity to conduct any redirect examination that you believe is appropriate. So, the court will overrule the objection. Counselor, go ahead and proceed.
Thank you. You stated that there are a lot of people in a certain area, then the phone will further connect to a further tower with the best signal, correct?
Yes.
Isn't it true that you only subpoenaed Avery's cell phone tower records and no one else is in the vicinity?
That is correct.
You also found that there were several calls and texts by Taylor Perkins to Avery Becker, correct?
That is correct.
And you were called to a scene where a victim was found dead near their porch, correct?
Yes.
Was the victim face down with a stab wound to their shoulder?
Yes.
Was there a knife near the victim?
Yes.
And are the knives the same? And Mr. Brockman would have to have been sitting down or not standing up at the angle they were stabbed, correct?
Yes, that is what I believe.
Okay. Ladies and gentlemen of the court, can we please turn to our attention as it has been marked as Exhibit 5?
Exhibit 5, all right, go ahead.
Yes. And Detective, can you also turn your attention to what has been marked as Exhibit 8?
Yes.
Do you recognize this exhibit?
Yes, Exhibit 8 is an image of the knife block in Mr. Brackman's kitchen with a single knife missing from the slot.
And is this a fair and accurate copy of this exhibit?
It is, yes.
And has the knife block been altered since the last time you took this picture?
I was not the one who took the picture, but to my knowledge, no, the knife block has not been altered.
Okay. Your Honor, I move to publish Exhibit 8 into evidence.
All right, thank you. From the people, any objection to Defense 8, please?
No objection, Your Honor.
All right, the court will admit Defense 8 into evidence. Counselor, go ahead and proceed.
Are Exhibits 5 and 8 the same color or style knife?
They are not.
You would say that the knives are both different from both exhibits?
Yes.
And let's move on to your experience a little. You have been a homicide detective for 13 years, correct?
I've been a detective for 7 years. I've been with the police for 13.
Okay. And you've received specialized training in investigating homicides?
I have, yes.
In those years, you investigated a number of different homicides?
Yes.
From those investigations, you understand the importance of properly collecting evidence?
This is, yes.
And properly preserving that evidence?
Yes.
You understand that if you do not properly collect and preserve the evidence, an improper result in your case might be reached?
Yes, that is a possibility.
And would you want an improper result reached in this case involving the murder of a citizen in the city?
Of course not.
Let's move on to a second. There was a broken plate on the floor of the home, correct?
Yes.
Were there pictures of the plate?
Yes, we took images of the plate.
And were there blood drops on that plate?
No.
There were no blood drops on the plate?
Not to my knowledge.
Okay, and are you familiar with cast-off blood?
Yes.
Was there cast-off blood?
There was.
At the scene? Did you photograph the cast-off blood?
My team did, yes.
And are those pictures in evidence?
No, they were corrupted.
So those pictures were not properly preserved and were corrupted under your investigation, correct?
We are unsure as to how they were corrupted, but we lost them, yes.
But you would state that they are still corrupted under your leadership and investigation?
Yes.
Did you see any surveillance cameras?
I did, yes.
Isn't it true that the Ring security system sends you a notification when someone is not on your property? Or on your property, sorry.
Usually, yes.
Isn't it also true that you can turn those notifications on and off?
Yes.
And you downloaded information from Mr. Brockman's Ring account, isn't that
I
right?
did, yes.
Isn't it true that you only subpoenaed his passwords and recordings?
Yes.
So you failed to subpoena Mr. Brockman's cell phone data to see if he had those notifications on or off.
That is correct.
Ladies and gentlemen of the court, do we recall seeing the videos that that the people played?
Yes, I do.
Okay. Detective, do you recall seeing those videos and remembering what was in those videos?
Yes.
And in those videos, can you see if the intruder was male or female?
No, it is not clearly visible.
Could you see their face?
No, it was covered by a mask.
Can you see their skin color?
No.
Can you see their eye color?
No.
Can you see their hair color?
No.
The intruder could have been anyone.
Any one of the approximate height and build of that same individual.
Okay. And did you look into Blair Rollins?
No, we did not.
So this could have been Blair Rollins and you wouldn't even have known.
Perhaps. It's unlikely, though.
It is your opinion that you have the person responsible for this murder, Avery Becker, correct?
Yes.
And that remains your opinion even knowing that the evidence was not properly preserved?
The evidence that was lost was not of a particular significance to the case, and so, yes.
The evidence that was corrupted under your investigation still was part of your investigation, correct?
Yes, but it was hardly an integral part of the investigation.
Okay. But it still remains your opinion that Avery Becker is the murderer in this case, even knowing that you cannot clearly identify the individual in the Ring doorbell footage.
Yes.
No further questions, Your Honor.
All right, thank you. From the people, any redirect examination, please?
Yes, Your Honor. Permission to begin?
Yes, go ahead, whenever you're ready, counsel.
Detective Markowitz, is it possible for a phone to connect with a less than optimal cell tower?
Yes.
Is it likely?
No.
Thank you.
Objection leading.
Counselor, any response?
Your Honor, that a question implied no specific answer. The witness was at liberty to answer as she would.
All right, thank you. The court will overrule the objection. The answer will not be stricken from the record. Counselor, go ahead and continue.
Detective Markowitz, could you remind us of the range of a cell tower?
Yes, an approximate 6-mile radius.
Would it have been practical to subpoena everyone's phone records who was in that 6-mile radius?
Goodness, no.
Thank you. Detective Markowitz, may I turn your attention to Exhibit 7 once again?
Of course.
Is this the knife drawer?
Yes, it is.
Are the knives in that drawer of a consistent make or pattern?
No, there's a selection.
Now, moving on, Detective Markowitz, are you aware of the consequences of your investigation?
Of course.
Are you aware that people might end up in jail?
Yes.
And you exercise the caution necessary for this business?
Of course.
Finally, Detective Markowitz, could you remind us how relevant are those blood drop images that were corrupted?
Really hardly at all.
Thank you, Your Honor. No further questions at this time.
All right, thank you. Detective Markowitz, you are free to go about your day. Thank you.
Thank you, Your Honor.
From the prosecution, please call your next witness. All right, and Counselor, I only see one individual on the screen, but when you have both the attorney and the witness ready.
Sorry,
go
my
ahead and
internet
proceed.
froze for a moment. I am here.
Oh, that's fine, Counselor. It's a difficult way of doing business nowadays. So, Counselor, go ahead and proceed. Who is your first witness? Who is your witness?
Kyle Kuzak.
All right, thank you. Could the witness please raise their right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I so swear.
All right, thank you. Counselor, go ahead and proceed when you're ready.
Thank you. Please state your name and spell your last for the record.
Kyle Kuzak, Kuzak.
What is your current job, Ms. Kuzak?
I'm a crime scene reconstruction investigator with the Denver Police Department.
And how long have you held this position?
I've held the position of crime scene reconstruction investigator with the Denver Police Department for 3 years, though I have been a crime scene reconstruction investigator for 19 years.
Are you certified in some way?
Yes, I received a certification from the Colorado Bureau of Investigation.
Have you investigated many crime scenes similar to this one?
Yes, I've worked with many different kinds of complex crime scenes, including homicides, armed robberies, domestic violence, burglaries and other property crimes, home invasions, and fatal accidents.
Thank you. Your Honor, I move to have this witness recognized as an expert in crime scene reconstruction.
All right, thank you. From the defense, any objection, please?
No objection, Your Honor.
All right, thank you. The court will accept the witness as an expert in the field proffered. And Counselor, go ahead and continue.
Thank you. Were you involved in investigating a crime related to this case?
Yes, I was.
Did you visit the crime scene?
Yes.
Have you looked over the evidence collected there?
Yes, I have.
Can you describe for the jury what kinds of evidence and what different pieces of evidence you reviewed?
Yes. I reviewed the photographs taken at the scene, as well as visiting the scene myself, as well as the 4 Ring security camera videos and the police reports involved with this case.
What physical evidence did you observe?
I noticed a broken plate lying on the kitchen floor when I visited the scene, as well as a knife block with one slot empty and an open knife drawer. There were also scuff marks near the back door. I understand that there was a knife lying on the floor, as well as, of course, the body of the deceased Mr. Brackman, but those had been taken away to the crime lab before I arrived at the scene.
Thank you. So you mentioned you saw the Ring doorbell videos. I would like to draw your attention to what has previously been marked as Exhibit 10. Have you seen this?
Just a moment.
Of course.
Yes, I have.
What is this?
This is the video taken from the Ring security camera by Mr. Brackman's front door, showing an intruder wearing a Red Devil's mask, as well as a baggy clothing and surgical gloves, approaching the front door and attempting to open it, and then finding it locked and moving around out of the frame of the camera.
Thank you. I would now like to draw your attention to Exhibit 11. Have you seen this before?
Yes, I have.
What is happening here?
The same intruder as in the previous video is entering Mr. Brackman's property through his back gate.
Thank you. Could you turn to Exhibit 12?
Yes.
Have you seen this?
Yes, I have.
What is it?
This is a video of the same intruder as in the previous videos, entering Mr. Brackman's house through his back door.
Thank you. You also mentioned you saw a knife block. If you could turn to Exhibit 8, have you seen this?
Yes, I have.
What is it?
This is a photograph taken at the crime scene of the knife block I mentioned.
Is this a fair and accurate representation of what you examined at that crime scene?
Yes, it is.
Thank you. Could you turn to Exhibit 7 now? Have you seen this?
Yes, I have.
What is it?
This is a photograph taken of the open knife drawer that I mentioned at the crime scene.
Is this also a fair and accurate representation of what you saw at the crime scene?
Yes, it is.
You also mentioned seeing a knife. If you could turn to Exhibit 5, have you seen this?
Yes.
What is it?
This is the photograph I examined for this case of the knife that was found on the floor of Mr. Brackman's house, covered in blood.
Perfect. And where is this knife located according to the picture?
It's on the floor of Mr. Brackman's front hall.
Thank you. Now could you turn to Exhibit 6, please? Have you seen this?
Yes.
What is it?
This is a photograph of the same knife as in the previous photograph, taken this time at the crime lab when it was taken away for measurement and examination.
Does the size of the wound line up with this measurement?
Yes, it does.
Thank you. Now could you please turn to Exhibit 18?
Just a moment.
Of course.
Yes.
Have you seen this?
Yes, I have.
What is it?
This is a photograph taken of the scuff marks that I mentioned previously near the back door of Mr. Brackman's house.
Is this a fair and accurate representation of what you saw at the crime scene?
Yes, it is.
Your Honor, I would like to enter Exhibit 18 as evidence.
All right, thank you. Any objection to People's 18 from the defense?
No, Your Honor.
All right, thank you. The court will accept People's 18 into evidence. Counselor, go ahead and proceed.
Thank you. Now please turn to Exhibit 9.
Once again, just a moment. Yes?
Okay, have you seen this?
Yes, I have.
What is it?
This is a photograph of the broken plate that was found lying on the floor of Mr. Brackman's house.
Is this a fair and accurate representation of what you examined?
Yes, it is.
Your Honor, I move to enter Exhibit 9 as evidence.
Exhibit 9, any objections, counsel?
Objection, relevance.
All right, thank you. And from the people, any response?
This broken plate was located on the floor of the crime scene. It is involved in the crime. It was near where Mr. Brackman died, so it's relevant in that way.
All right, thank you. The court will overrule the objection and I will admit into evidence People's 19. Counselor, go ahead.
Thank you. And could you finally turn to Exhibit 13? Have you seen this?
Yes, I have.
What is it?
This is the Ring security camera video of the same intruder as in the first 3 videos, exiting Mr. Brackman's residence at a run through his front door.
Thank you. Have you looked over and analyzed all of these pieces of evidence?
Yes, I have.
And based on your expertise as a crime scene reconstruction investigator, what conclusions did you come to about how the crime occurred based on this?
I believe that an intruder wearing a Red Devil's mask and baggy clothing, as well as surgical gloves, moved towards Mr. Brackman's property, approaching the front door. Trying the front door and finding it locked, the intruder moved around through the back gate and then through the back door. Mr. Brackman, who had been alerted by his Ring security cameras to the intruder's presence, was prepared with a knife, and a struggle ensued, causing the scuff marks and the broken plate. I believe the knife was taken from the knife block with one slot empty. During the course of the struggle, the intruder somehow gained control of the knife and managed to stab Mr. Brackman in his upper left shoulder. And then, breaking free, the intruder ran out through the front door. Mr. Brackman chased after the intruder, but after pulling out the knife, bled out rapidly and died.
Thank you. No further questions, Your Honor.
All right, thank you. From the defense, any cross-examination, please?
Yes, Your Honor. Mr. Kuzak, is it correct that you currently work as a civilian employee and not a police officer?
That is correct, yes.
And you are only certified in crime scene reconstruction, yes?
That is true.
Is it true that in this case, the perpetrator's face was never seen?
Yes, it is.
And would you say you were able to recreate all events from the evidence from this case?
I was not.
Some of this investigation was from some police reports, that's correct, right?
Yes.
And would you say it was true that reading a report would give the same understanding as being there in person?
Not necessarily.
To be clear, so you would say that reading a report does give the same understanding as being there in person?
The report doesn't necessarily have all of the details, though the information in it is accurate. So
but when it comes down to it, it would not be the same as being there in person?
Not necessarily, no.
Would you say that you wished you had more evidence?
Yes, though that is naturally always true.
And it is true that you visited the scene of the crime after it was processed?
Yes.
And it is also true that you believe conclusions that Blake Van Owen has made were outside of your expertise, correct? Some of the claims.
Some of them, yes.
No further questions, Your Honor.
All right, thank you. From the people, any redirect examination?
No to redirect, Your Honor.
All right, thank you. Investigator, you are free to leave. Thank you, sir. Or thank you, ma'am. And from the people, you may call your next witness. Thank you. All right, thank you. Counselor, go ahead and proceed whenever you're ready.
Ms. Fuentes, please state your name and spell your last for the record.
And I'm sorry, Ms. Fuentes, will you raise your right hand for me, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. I apologize, Counselor. Go ahead, proceed.
Please state your name and spell your last for the record.
Alexey Fuentes. Sifuentes.
How do you know Miss Becker?
We were best friends, and she was the one that introduced me to mock trial.
How long were you in mock trial?
I was in mock trial for 3 years up until my junior year.
And how was your relationship with the defendant?
We were really good friends. Like I said, we were best friends.
How did you know Mr. Brackman?
He was our mock trial coach for the 3 years that we were in mock trial, that I was in mock trial.
During your time at mock trial, were you able to observe the relationship between Mr. Brackman and the defendant?
Yes, I was.
Could you describe the relationship between Ms. Becker and Mr. Brackman?
And I'm sorry, counsel, if you could give me a moment. From the defense, I think I heard you state an objection. It was very, very faint. So if that is what you were doing, could you repeat that?
Yeah, objection speculation.
Objection is speculation. All right, thank you. From the people, any response to the speculation objection?
Ms. Fuentes just testified to being able to observe the relationship between Mr. Brackman and the defendant.
All right, thank you. And from the defense, any reply?
No, Your Honor.
All right, thank you. The court will overrule the objection. The witness can go ahead and answer. From the people, if you need to re-ask the question, go ahead.
Okay. Could you describe the relationship between Ms. Becker and Mr. Brackman?
Yes, they would get into many arguments.
And those arguments, did they ever happen in public?
Yes, in front of many people.
Did those arguments ever escalate?
Yes, this one time it led to Avery vandalizing Mr. Brackman's 1986 Porsche 911.
Could you go into the vandalism incident?
Well, Mr. Brackman was trying to explain to Avery how she couldn't.
Objection, hearsay.
All right, thank you. Prosecution, any response?
This is less what they said and more about what the argument was about, and it leads to what happened at the vandalism incident.
And from the defense, any reply?
Your Honor, I believe that this is an out-of-court statement that is being asserted for the truth of the matter.
And from the prosecution, briefly, if it's not being introduced for the truth of the matter asserted, what purpose is the statement being introduced for?
It gives context as to why the vandalism incident ever happened in the first place.
All right,
Your
thank you. For the purposes of the competition, the court is going to overrule the objection. The witness can go ahead and answer. Counselor, for the prosecution, go ahead.
Can you repeat the question?
Could you explain the vandalism incident?
Yes. So Mr. Brackman was trying to explain to Avery why she could not not prepare for mock trial. Avery then got really mad and she grabbed a Sharpie and vandalized Mr. Brackman's Porsche.
And what did Mr. Brackman do after she vandalized his Porsche?
Mr. Brackman kicked Avery off the team for good.
Did the defendant contact you afterwards?
Objection leading.
And I'm sorry, the objection was leading?
Yes, Your Honor.
Okay, I'm sorry, Counselor. It's just a little bit hard to hear you. From the prosecution, any response?
May I ask what question they objected to? Was it about the contact?
Could you, I believe it was the last question. Could you repeat the question you were objecting to from the defense counselor? I'm sorry, I think there's a little bit of lag and delay here, at least from my end.
Did the defendant contact?
From the defense, can you repeat the question that you were specifically objecting to?
Yes, it was, did the defendant contact you?
All right, thank you. And from the prosecution, any response?
This isn't a leading question. There are multiple answers to this question, and I don't give any, in conclusion as to what she should answer.
All right, thank you. The court will overrule the objection. Counselor from the prosecution, go ahead. And if you need to re-ask that question, go ahead.
Did the defendant contact you afterwards?
Yes, she texted me and asked if I could ask if.
And I'm sorry, the objection was hearsay, Counselor?
Yes, Your Honor.
All right, thank you. Prosecution, any response?
Yes. This is a statement of a party opponent.
All right, thank you. The court will overrule the objection. The witness can go ahead and answer.
Can you repeat the question one more time?
Did the defendant contact you afterwards?
Yes, she texted me and asked if I could ask Mr. Brackman for her if she could be let back on the team.
And did you ask Mr. Brackman for her?
Yes, I did, but he refused.
How did the defendant react to that?
Objection, speculation.
And I think you said speculation, Counselor, is that right?
Yes, Your Honor.
All right, thank you. From the prosecution, any response?
Yes. Ms. Fuentes, you could tell how the defendant reacted to not being allowed back on the team, yes?
And I'm sorry, prosecution, any response to the defendant's objection?
Yes. Am I frozen?
I think I'm sorry, I think I might be having a little bit of lag on my end. So the objection was speculation. Is that, am I recalling that correct from the defense?
Yes, Your Honor.
All right, thank you. And from the prosecution, any response to the defendant's objection as to speculation?
It's not speculation, as Alexey Fuentes has seen Miss Becker, what she looks like and how she reacted, and she can tell that she was mad.
All right, thank you. So I will allow questioning of the witness's observation of the other party's demeanor and physical demeanor, but the witness is not allowed to answer any assumptions of what the party's internal thought processes were. So with that proviso from the prosecution, go ahead.
Did she say this in person?
No, this happened all over text.
Mm-hmm. Your Honor, I'd like to direct your attention, as well as opposing counsel's attention, to what has been previously marked for identification purposes as Exhibit 14 in your exhibit packet.
All right, Exhibit 14, go ahead, Counselor.
Ms. Fuentes, do you have your exhibit packet in front of you?
Yes, I do.
Could you please refer to what has been previously marked for identification purposes as Exhibit 14?
Yes, I can.
Could you describe the contents of this photo?
These are the screenshots that I emailed to the detective of the conversation I had with Avery about this situation.
And is this a fair and accurate representation of the screenshots?
Yes, it is.
Your Honor, I move what has been previously marked as Exhibit 14. Oh. Never mind.
Yeah, I believe that was already admitted
I must have
into
cut out
evidence.
when it was.
All right, thank you. Go ahead, Counselor.
Your Honor,
Okay.
the opposing counsel for prosecution has gone over their time for 25 total.
All right, thank you. Pursuant to the rules of the competition, we will cease questioning at that point in time. And the scoring judges are to give that matter whatever weight they deem fit with respect to their scoring of the team as it relates to that witness. From the defense, go ahead and proceed.
Thank you, Your Honor. Isn't it true that you were accused of faking text messages between yourself and Avery Becker?
Yes. No, it wasn't.
You were not accused of faking text messages?
No.
Do you remember writing a statement before the trial?
Yes, I do.
And do you remember being complete in the statement?
Yes, I do.
Do you remember being honest?
Yes.
Do you remember being accurate?
Yes.
And Ms. Fuentes, do you have your witness testimony with you?
Yes, I do.
Okay, I would like to direct your attention to lines 98 and 99. Sorry, 1 second. Yes, lines 98 and 99, where you say, quote, "That's how I learned I was basically being accused of faking text messages from Avery," end quote. Did I read that correctly?
Yes, I must have mistaken it. I'm sorry.
Okay. Let's talk about your police interview. Did you bring your phone to that interview?
No, it was a very old and damaged phone, and I left it at home charging.
Is it correct that you just sent screenshots of the text messages between Avery and yourself to the detective?
Yes, it was.
And isn't it true that you got a new phone after sending the screenshots?
Yes, my old phone was very old and damaged, like I said.
Okay, and are you aware that Mr. Becker lost his phone the night of March 5th?
Yes, I did.
And isn't it true you had played a game on his phone that night?
Yes.
Moving on to your relationship with Avery Becker. Isn't it true that you think the mock trial team was better off without Avery on it?
Yes, but she was a great student.
Now, is it correct that you're excited to have a larger role when Avery was kicked off the team?
Yes, I am.
So you took mock trial pretty seriously, correct?
Yes.
And didn't it bother you that Avery would make things up on the fly?
Yes, it did. It frustrated everyone.
And isn't it true that you thought Avery was just coasting on good looks alone, not real talent?
Yes, it was.
But after saying all of this about the defendant, Mr. Becker, Ms. Fuentes, isn't it true that you said, quote, "We are basically best friends," end quote, in reference to Avery Becker?
We are best friends.
Okay, no further questions, Your Honor.
All right, thank you. And Ms. Azurda, are you still on the line?
Yes, Your Honor, I am.
Just a point of clarification on the rules, the time limitation, that includes both time for direct and redirect examination. Is that correct? So if the time has expired, there's no time left over for redirect. Am I understanding that correctly?
That's correct.
All right, thank you. I just wanted to make sure I was clear. All right, thank you. The witness is free to leave. Thank you. And from the prosecution, any further prosecution witnesses, please?
No, Your Honor.
All right, thank you. And does the prosecution rest at this time?
The prosecution rests, Your Honor.
All right, thank you. From the defense, does the defense have any witnesses?
Yes, Your Honor, I'd like to call Taylor Perkins to the witness stand.
All right, thank you. To the witness, can you raise your right hand for me, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I swear.
All right, thank you. Counselor, go ahead.
Thank you. Please state your first and last name and spell your last for the record.
Taylor Perkins, Perkins.
Where did you go to high school?
I went to high school at Colorado High School.
And what clubs did you participate in while you were there?
While I was there, I was on the mock trial team.
And who was the coach?
Our coach was Mackenzie Brackman.
And are you familiar with Avery Becker?
Yeah, she's my best friend. He's my best friend.
Now, there was an instance where Avery was kicked off the team. What did you do in response to that?
When he was kicked off the team, I stepped down from A team to B team so that he could get back onto A team.
Are you familiar with Alexey Fuentes?
Yes, I am.
How so?
He was also on the mock trial team.
Did you ever have an opportunity to see Avery and Alex interact with each other?
Multiple times, yes.
Can you tell the jury about the relationship between Alex and Avery in which you witnessed?
They weren't overly fond of each other. Avery, on multiple occasions, was not so happy with Alex after them talking.
What was Alex's response when Avery was kicked off the team?
He didn't seem to care that much. He was more happy that he would finally get the better positions on the team.
Objection, speculation.
And counsel, any response?
Your Honor, I believe I've laid enough foundation, and I'm asking the witness, based on personal knowledge, how they saw the relationship between Avery and Alex.
All right, thank you. And from the prosecution, any reply?
The witness testified that this is too deep an inference. He said that Miss Fuentes was happy for this reason or that reason, and he has no reason to know that.
All right, thank you. I am going to sustain the objection. Counsel, if you want to re-ask the question just about what the witnesses observed as to the demeanor, you can certainly ask that. But any actual testimony about what the witness was actually feeling is objectionable. So if you would like to re-ask the question, go ahead.
Thank you, Your Honor. Moving on to the day of March 5th, what happened?
Me and Avery went to Fry Shack together.
And who showed up at the Fry Shack?
The mock trial team, they showed up.
And did you see Alex and Avery speak at all?
Yes, I did. They talked briefly.
And how did Avery respond to the fact that Alex was talking to her?
He stormed off. He was kind of upset. So he went to the bathroom. He left his cell phone. Well, he did.
Was that unusual for Avery to leave his phone behind?
Yes, very unusual. He typically has his phone on him at all times.
And where did Avery leave the phone?
Just on the table.
And where was Alex at this time?
He was also at that table with me.
And do you recall if Avery picked up the phone when you left Fry Shack?
I'm not sure. I just remember that he did not have it the next day.
Okay, let's talk about the morning of March 6th. What happened?
Avery picked me up for school. That's when we realized his phone was missing, so we decided to just ditch school and look for it.
And how long did you guys search for it?
Pretty much all day.
Now, the afternoon of March 6th, where did you guys go?
We went back to Fry Shack.
And who showed up at Fry Shack that night?
Again, the mock trial team showed up.
And why were they not at practice?
They told us that coach had not shown up, so they just followed the 15-minute rule and ended up coming here instead.
And what did you find out had later happened?
I later found out that Coach Brackman had been murdered.
And just to reiterate for the jury, were you with Avery all day on March 6th, the day of the murder?
Yes.
No further questions, Your Honor.
All right, thank you. Any cross-examination, please?
Yes, Your Honor. May I begin?
Yes, go ahead whenever you're ready, Counselor.
Thank you. You know Miss Becker well, Mr. Becker well?
Yes.
You would identify yourselves as best friends?
Yes, I would.
So you're around Mr. Becker a lot?
Quite a bit, yes.
You were on the mock trial team together?
Yes, I was.
So you saw many of Mr. Becker and Mr. Brackman's interactions?
I did.
How would you describe Mr. Becker and Mr. Brackman's relationship as rocky?
Yes.
Just before regionals last year, Mr. Becker was demoted to B team?
Correct.
This was as a result of Mr. Brackman finding him unprepared?
Yes. Yes, it is.
So you gave up your spot?
I did.
To help him back on the team?
That is correct.
Mr. Becker and Mr. Brackman got into an argument over this turn of events?
I believe so, yes.
So Mr. Becker ended up storming out of the room in a huff?
Yes.
And on the way grabbed a permanent marker?
Unbeknownst to him, but yes.
After getting the marker, Mr. Becker then went and wrote on Mr. Brackman's car?
Correct.
His Porsche?
I believe so, yes.
Objection relevance.
Any response?
It's a prized possession of Mr. Brackman's. It goes to show just how deep this went.
The court will overrule the objection. Counselor, go ahead and proceed.
Thank you. Mr. Brackman kicked Mr. Becker off the team for this behavior?
Yes.
Mr. Becker tried to get back on in multiple different ways?
Yeah, he texted the team and showed up one day.
but Mr. Brackman still refused?
Yes.
You and Mr. Becker ran into the team on March 5th.
Yes, a fresh act.
And once again, he stormed off?
He stormed off to the bathroom, yes.
You talked to Alexey Fuentes while Mr. Becker was away?
Briefly, yes.
And she expressed sympathy for Mr. Becker's situation?
Yes.
You and Mr. Becker both left shortly after this?
Yes, we did.
However, you do not remember whether Mr. Becker retrieved his phone before leaving?
I don't believe he did, no. I remember that part, though.
You saw Mr. Becker on the morning of March 6th?
Yes, he picked me up from for school.
And you both claim that then and only then did you realize that his phone was missing?
Correct.
After almost a whole night of him not having his phone?
Yes.
After you both realized this, a number of hours after Mr. Becker supposedly lost his phone, you two decided to retrace your steps?
That is correct.
And you did this all day?
Yes. Yes, we did.
Just you two?
Yes, just us.
Your Honor, I have nothing further. Thank you.
All right, thank you. Any redirect, counsel?
Yes, Your Honor.
Go ahead.
So, do you remember if Avery Becker picked up his phone the night at the Fry Shack?
No, I don't remember.
And you were with Avery Becker all day on March 6th, correct?
Correct.
Objection, leading question.
Objection leading, and Counselor, any response?
Your Honor, I'm not asking this as a yes or no question. The witness may simply answer no, but they have testified as to saying that they were with Avery Becker all day on March 6th.
All right, the court will sustain the objection. Counsel, if you want to rephrase that question, go ahead.
Okay, thank you. Was Avery Becker with you all day on March 6th?
Yes, she was. He was.
And in your personal knowledge, did your best friend commit these crimes?
No. Avery isn't the type to do that.
Thank you. No further questions, Your Honor.
All right, thank you. To the witness, you are released and free to go about your day. Thank you. And counsel, go ahead and call your next witness.
The defense calls Professor Blake Van Owen to the stand.
All right, thank you. To the witness, can you raise your right hand for me, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Counsel, go ahead.
Professor Blake Van Owen, please state your first and spell your last for the record.
My first name is Blake and my last name is Van Owen, Vanowen.
What do you do, Professor?
I am currently a private investigator and a professor on police procedures, but I did leave the I did used to work in the police department, but I did leave.
And why did you leave?
I left after an incident where I had injured a young woman of color during an arrest. I was cleared of all wrongdoing by the department as the technique I used was approved.
And why did you officially stop being a police officer?
I was disillusioned with police work after that because of the tactics and techniques that I was taught, so I quit.
And what do you do with your time as a professor?
As a professor, I started teaching police procedures at a community college. Then I got my master's degree in criminal justice, and now I teach courses at CU Denver.
Outside of your teaching obligations, what do you do?
I help out as an expert witness in the courtroom in police practices, the use of force, false arrest, forensic evidence techniques, crime scene reconstruction, and cell tower analysis, as well as police investigation tactics.
Your Honor, at this time, I'd like to enter Professor Blake Van Owen as an expert in police practices, forensic evidence techniques, crime scene reconstruction, and general police investigation tactics.
All right, thank you. Any response from the people?
No objection, Your Honor.
All right, thank you. I will accept the witness as an expert in the fields proffered. Counselor, go ahead and proceed.
Did you prepare an expert report in this case?
Yes, I did. It's in Exhibit 20.
Okay. Your Honor, ladies and gentlemen of the jury and Professor, can you please everyone turn your attention to what has been marked as Exhibit 20?
All right, thank you, Counselor. Go ahead.
Professor, I'm showing you what has been marked as Exhibit 20. What is this?
This is my my end report after the investigation I conducted.
And how are you familiar with this exhibit?
I wrote it after I completed my investigation.
And is this a fair and accurate copy of this exhibit?
Yes.
And Your Honor, at this time, I'd like to move Exhibit 20 into evidence.
20? From
Yes.
the people, any objection?
Objection, hearsay.
Okay, thank you. And Counselor, any response?
Your Honor, this is not his hearsay, as my witness has been entered as an expert, and this is her expert opinion, and she wrote this as her expert conclusion on this case.
All right, the court will overrule the objection. I will accept Exhibit 20 into evidence. Counselor, go ahead and proceed.
Let's move on to the evidence in this case. What is your expert opinion on the stabbing itself?
So since the direction of force that was applied to the knife was a downward motion and aims toward the aorta, which suggests the victim was sitting down, and in order to stab someone in the back like that, the assailant would have to be standing over the victim. This indicates the assailant surprised Mr. Brackman.
And ladies and gentlemen of the jury, Your Honor, and Professor, can we please turn our exhibits, which have already been entered, 4 and 5? Professor, do you have these exhibits in front of you?
I'm sorry, what was that?
Do you have these exhibits in front of you?
Yes.
What can you tell the jury about the style of these knives?
First of all, the knife was a different style of brand. So the knife used to impale Mr. Brackman was a different style and brand from all the knives on the knife block.
Okay. And let's move on to the entry of the home. Did you notice any signs of forced entry?
Not necessarily. There were scuff marks on the floor, which the prosecution believes this was a sign of forced entry. The fact is, you can't date scuff marks. They could be from 5 years ago or 5 months ago.
And you are aware of the missing evidence that Detective Margaret's corrupted, correct?
Yes, this was important to the investigation because there were no pictures of the cast up blood or the blood spatter evidence.
And can you tell the jury why these pictures were so important?
Yes, these pictures could have determined where Mr. Brackman was stabbed, and they could have been crucial to part of my report, but since I didn't have them, we wouldn't know.
Let's move on to the Ring doorbell videos. Did you see any video cameras at the scene?
Yes, I noticed a few Ring security cameras.
Your Honor, ladies and gentlemen of the jury, and Professor, Exhibit 10 has already been entered into evidence. Do we all recall this video?
Yes, go ahead, Counselor.
Professor, can you tell the identity of the intruder in this video?
As we've seen in the video, you cannot determine any features on the intruder, making it close to impossible to identify them. It could have been anyone.
Are you aware that the Ring doorbell apps allows push notifications?
Yes, but you can turn them on.
Can we tell if Mr. Brackman had these notifications on or off?
No, you can't, because so Detective Markowitz failed to retrieve those records.
Let's move on to Blair Rollins. In your testimony and report, you state that Blair Rollins had a better motive to murder Mr. Brackman. Can you tell the court how you came to that conclusion?
Yes, Blair Rollins is the child of Jonathan Rollins, one of Mr. Brockman's ex-clients. Mr. Brockman represented Mr. Rollins when Mr. Rollins was charged with murder. Mr. Brockman lost the case and Mr. Rollins was sentenced to life in prison. Blair spoke on behalf of her dad the day of the sentencing, so she was in the courtroom. After sentencing, Mr. Rollins was being escorted back to jail, and on the way he screamed that Mr. Brockman was going to die.
And Your Honor, ladies and gentlemen of the jury, and Professor, can you please turn our attention to what has been marked as Exhibit 22?
22?
Yes. Professor, this is an audio recording from the courtroom where Blair's dad, Jonathan Rollins, was being taken back to his prison cell. Do you recall listening to this? Sorry?
Yes.
And when you last listened to this, was this a fair and accurate representation of what Jonathan Rollins said?
Yes.
Your Honor, at this time, we'd like to enter Exhibit 22 into evidence.
22. And counsel for the prosecution, any response?
Objection hearsay.
All right, thank you. And from the defense, any response to that objection?
Your Honor, defense believes that this falls under Rules of Evidence 802, 803.2 excited utterance, 803.8 public records, or 803.6b regular activity.
As to the excited utterance exception, can you make a offer of proof of what you believe the exhibit to indicate?
Yes. The declarant was under stress after being sentenced to life in prison due to Coach Brockman's failure to represent, or Coach Brockman's failure to get his case dismissed. So Jonathan Rollins was obviously under distress and was very emotional at this time.
All right, thank you. I will overrule the objection. I will admit into evidence defense exhibit 22. Counselor, go ahead.
Thank you. Your Honor, at this time, I'd like to pause the time for my co-counsel to play the audio recording.
All right, go ahead, sir.
I'll get you back, Brockman, if it's the last thing I do.
Has everyone had enough time?
Yes, go ahead and proceed, Counselor.
Thank you. Professor Van Owen, can you tell the court how you believe that Blair Rollins is a more reasonable suspect than Avery Becker?
Yes. Blair was not at school the day of the murder. Neither were Avery and Taylor, but as we've learned, they were looking into looking for Avery's missing phone. It is possible that Blair stole Avery's phone and took it with her to make Avery look like a clear suspect.
Objection speculation.
All right, thank you. Counsel, any response?
Your Honor, my witness is providing her expert opinion on this case, and she's providing how there could have been another motive to this, another person with a better motive. So we can understand how Avery is not the only person in line for questioning.
All right, thank you. As the witness has been endorsed as an expert, the court will overrule the objection. And Counselor, go ahead and proceed.
Professor Van Owen, your witness testimony and your expert report have a final conclusion. Can you please let us know what that is?
My final conclusion was that Mr. Brockman was attacked by an intruder, but was attacked from behind. And he was attacked from behind, and it was premeditated, and the intruder brought the knife with them.
Thank you, Your Honor. No further questions.
All right, thank you. Cross-examination.
Professor Van Owen, you were a police officer?
Yes.
For 9 months?
Yes.
Until there was an incident?
Yes, but because I had moral conflicts after that incident, I resigned.
And then you started teaching?
Yes. Mm-hmm.
And you earned your master's in criminal justice
Yes.
from Ashford University's online program.
Yes.
And you expect to be referred to as professor
Yes.
because you earned it.
I did. I went to school for my degree.
You also consider yourself a check on the power of police.
Yes, I do.
And now you testify as a defense expert.
Yes, because I believe the police should know what they're doing wrong.
And you've only ever testified as a defense expert.
Yes.
Objection, relevance, Your Honor.
Thank you. Relevance, any response from the people?
This proves a likely bias towards the defense.
All right, thank you. I will overrule the objection. The witness can go ahead and answer. Counselor, go ahead and proceed.
And you've met Mr. Cusack before,
Yes, I have.
and you like him?
Not really. I think he's a little arrogant.
And you don't think Detective Markowitz is very good at his job?
I feel like he got an idea in his mind and that's the only possibility it could be.
You don't, that was a yes or no answer. You don't think Detective Markowitz is very good at his job?
I think he has some good aspects.
Please answer the question, Professor Van Owen. You don't think Detective Markowitz is very good at his job?
I mean, everybody has their weaknesses.
So was that a no?
Yes, I don't think he's very good at his job.
And Professor Van Owen, you're being paid to be here?
Yes, I am. But it's not about the money.
And as of right now, you've been charged $7,000?
Yes, but like I said, it's not about the money for me. I make plenty of money over the year through my teaching and my other private investigation cases. I just want to get to the truth.
Moving on, you expect that expense will increase by at least $1,000?
Yes, to account for my time testifying and my investigation.
No further questions, Your Honor.
All right, thank you. Counsel, any redirect examination?
Yes, Your Honor. May I begin?
Yes, go ahead.
Thank you. Professor, would you say if you're getting paid $10,000 or $100, you would do less or more work?
I would do the same amount because at the end of the day, I'm just trying to get to the truth of the matter.
So no matter what you get paid, you are trying to look for the truth?
Yes.
And Professor, do you believe that Avery Becker could have done this?
No, I do not.
No further questions, Your Honor.
All right, thank you. To the witness, you are released from your subpoena. You can go about your day. Thank you. And counsel, you can go ahead and call your next witness.
Your Honor, the defense calls Avery Becker to the stand.
All right, thank you. I see everybody on the line. Counsel, go ahead and proceed when you're ready. Oh, I'm sorry. And to the witness, can you raise your right hand for me, please? You swear or affirm under penalty of perjury that the testimony you're about to give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Counsel, go ahead.
Thank you very much, Your Honor. Can you please state your name and spell the last for the record?
Avery Becker, Becker.
Mr. Becker, why are you here today?
I'm being charged with first-degree murder and second-degree burglary of a dwelling.
And how did you know Mr. Brackman?
He was my mock trial coach.
Did you ever have any disputes with Mr. Brackman?
Yes.
Where did these disputes take place?
Both inside and outside of mock trial.
What disputes took place inside of mock trial?
He would call me lazy and unprepared.
And how did this make you feel?
It was frustrating because I was really good at mock trial, and I could perform a cross-examination just by listening to a witness's story.
What disputes took place outside of mock trial?
He told me that I rely on my good looks and I didn't deserve the best attorney award. And so I took what I thought was a temporary marker and I drew on his car.
And to be clear, were you aware that the marker was permanent?
No, I thought it was a dry erase marker.
How did Mr. Brackman respond to this?
He got super mad and kicked me off the mock trial team.
And how did you feel about being taken off the team?
I was super upset. I was the best attorney and it was very important to me.
After the incident involving Mr. Brackman's car, did you ever attempt to reach out?
Yes, I tried to go to his office, but his secretary said he was unable to speak.
And were you ever able to contact him?
No, I sent a couple text messages trying to apologize, but I never got a response.
The day before the murder, where were you?
I was at the Fry Shack with my best friend, Taylor.
And what happened while you were at the Fry Shack?
We saw some of the mock trial team, including Alexey Fuentes.
So you mentioned Alexi Fuentes. What is your relationship with him?
We're not really friends. We've never really gotten along, and he's on the mock trial team as well.
And did anything else happen that night?
Yes, I realized I lost my phone.
Did you ever happen to find your phone?
No,
And the day of the murder, where were you?
I was with Taylor trying to find my phone.
After searching that day, did you ever end up finding your phone?
No.
To your best knowledge, and this is purely as a guess, what would you say happened to your phone?
Objection, speculation.
Thank you. Any response, counsel?
Your Honor, I'm not offering this as a fact. I'm merely asking him to, of his best knowledge, explain what he would think happened to his phone. I've already established that he has connections with the people in this case.
All right, thank you. I will go ahead and overrule the objection. The witness can answer. Counselor, go ahead.
Would you like me to ask the question again, Mr. Becker?
Yes, please.
To your best knowledge, what would be your guess as to what happened to your phone?
If I were to guess, I would say that Alex took my phone.
Back to Mr. Brackman. Did you know of anything?
Lack of foundation.
And I'm sorry, I didn't hear, Counselor, I didn't hear the question yet. Counsel, if you could go ahead and ask your question, and then for the prosecution, if you could repeat your objection. So
I beg your pardon. There was a bit of delay, it seems. I was objecting to the last answer, but
the last answer. Okay, I'm sorry, Counselor. For the defense, any response to the objection to the last answer?
Your Honor, as I previously stated, he has connections to this case. I've laid a proper foundation of his relationship with Alexi Fuentes. And again, I'm not offering this as a fact, but merely as a guess to what he would say.
Thank you. Oh, and go ahead, Counselor.
Your Honor, there is insufficient basis for the witness to make such a guess without it being utterly irrelevant to the case.
All right, thank you. I will overrule the objection. Counselor, go ahead and move on.
Thank you, Your Honor.
Back to Mr. Brackman. Did you know of anybody else who had a bad relationship with him?
I know Blair Rollins did.
And how did you
speculation?
Speculation was the objection. All right, Counselor, any response?
Your Honor, I've established he's been on the team with these people, and I've established that he has connection to these people. Sorry, one second.
May I respond, Your Honor?
Go ahead, briefly.
Your Honor, there is insufficient basis for the relationship with Blair Rollins, who is just as much a part of this testimony as Alexi Fuentes.
All right, thank you. I will overrule the objection. Counselor, go ahead.
Thank you, Your Honor.
Thank you, Your Honor. Would you like me to ask the question one more time, Mr. Becker?
Yes, please.
Did you know of anybody else who had a bad relationship with Mr. Brackman?
Blair Rollins did, because Mr. Brackman was representing Blair Rollins' dad. And
what do you know about Blair?
Just that we're about the same height and build, and we're on the mock trial team together.
And is there anything about your relationship with Mr. Brackman that you would like to further say or explain?
We haven't always gotten along, but he was really supportive of the team and he got us to a good place.
Are you aware of the charges against you today?
Yes.
And did you commit these charges?
No, I was already very apologetic for the drawing on his car, and I just wish that I would have given him an apology.
No further questions, Your Honor.
All right, thank you. Counselor, any cross-examination?
Yes, Your Honor. Before I proceed with my cross-examination, may I ask for a time check?
Sure. Do we have the timekeepers on?
Yes, Your Honor.
And that should be, since you're just beginning, I believe that should be 20 minutes. Is that correct?
Yes, 20 minutes.
All right, thank you. Counselor, go ahead.
Mr. Becker, you were good at mock trial?
Yes, I was one of the best attorneys.
Exceptionally good.
Yes, I won Best Attorney Award.
But throughout your mock trial career, you didn't get along with your coach, Mr. Brackman?
Correct. He would call me lazy and unprepared and even rewrite my closing arguments.
Because he thought you didn't put in the work.
Correct.
And you in turn thought Mr. Brackman was a bad lawyer.
I thought that because I've heard that from a couple of people that he's represented.
You thought that, though?
Yes.
You argued with him?
Yes.
Often?
Correct.
And then at regionals of 2020, you won 2 awards.
Yes.
You earned these awards.
For being best attorney.
Mr. Brackman didn't think so.
No, he told me I was using my good looks for earning these awards.
And he said you didn't deserve these awards.
Correct.
You were angry?
Yes.
Furious, even.
As anyone would be.
You stormed out.
Yes.
You grabbed a marker.
Yes, I did.
You stalked over to his car.
Yeah.
And you wrote Worst Attorney Award across the hood.
Yes.
Of his prized 1998 Porsche.
Correct.
And that's when Mr. Brackman kicked you off the team.
Yeah, he came out and he yelled at me and told me that I was off the team.
And you tried to get back on?
I did, yeah.
Mr. Brackman never responded?
He didn't, and that's when I coordinated with Taylor to get back on the team.
You spoke to your mother about your anger?
Yes.
And you said you'd get back at Mr. Brackman?
Yes, I did.
But you didn't tell her about the car?
Correct.
Mr. Becker, Taylor Perkins is your friend?
My best friend.
When you were demoted, Taylor quit from the A team.
Yeah, so that I could get back onto the A team.
And when you lost your phone, supposedly, Taylor helped you search for it?
Yes.
Skipping school?
Correct.
All day?
Yes.
Mr. Becker, on March 5th, you were at Fry Shack?
Yes, with Taylor.
Speaking with other students?
From the mock trial team, yeah.
You had your phone?
Yes.
This is the same phone that you can't use at home?
Yes.
Because your mother doesn't let you?
Correct.
The same phone you use to text?
Yes.
At mock trial?
Yes.
With Taylor Perkins?
Yes.
Because you can't text Taylor Perkins at home?
Oh, correct.
This is the same phone you searched for?
Yes.
For most of March 6th?
Yes.
Skipping school?
Yes.
And searching all over the mall?
Yes.
In order to find this phone?
Yes.
This phone you forgot?
Yes.
For the entirety of the evening of March 5th to the morning of March 6th.
Yes, I had just realized that I lost it on the morning of March 6th.
Thank you, Your Honor. No further questions.
All right, thank you. Any redirect examination?
Yes, Your Honor.
All right, go ahead.
Mr. Becker, to be clear, was the marker that you used on the car, did you know that it was going to be permanent?
No, I thought it was a dry erase marker.
No further questions, Your Honor.
All right, thank you. Thank you, sir. Your testimony is completed. From the defense, any further witnesses?
No, Your Honor.
All right, thank you. Does the defense rest?
Yes, Your Honor.
All right, thank you. The testimony in this case is now complete. We will proceed to closing arguments from the prosecution. Any closing argument, please?
Yes, Your Honor.
Oh, and I'm sorry, from the prosecution, do you wish to reserve time for rebuttal?
Yes, Your Honor.
How much time?
Any remaining time.
All right, thank you. Go ahead, sir.
Avery Becker has always assumed he was immune from consequence. He assumed that there would be no consequences for his lack of effort in mock trial. He assumed there would be no consequences for repeatedly defying his coach, Mr. Brackman. He assumed there would be no consequences for defacing and vandalizing the hood of his coach's car. And he assumed ultimately there would be no consequences for his attempt to burglarize his coach's home. On March 6th, Avery Becker came to Mr. Brackman's home with the explicit and stated intent to commit second-degree burglary. He entered surreptitiously, illegally, uninvited. When Mr. Becker left Mr. Brackman's home, he left Mr. Brackman alone, lying in a pool of his own blood spilled by the wounds that Mr. Becker himself inflicted. Mr. Brackman died of those wounds, making Mr. Avery Becker guilty of first-degree felony murder. Mr. Becker was wrong about consequences and always has been. He cannot evade the consequences of his actions, especially when those consequences are mandated by law. Members of the jury, it is your duty to enforce these consequences today and to produce a verdict of guilty. Mr. Brackman has already suffered the consequences of Mr. Becker's rash action. It is time that Avery Becker suffer the same. Two separate crime scene investigative experts examined the scene of the crime, and both concluded that Mr. Avery Becker committed the murder. Miss Kyle Cusack conducted a thorough crime scene reconstruction, relying on 19 years of expertise. That reconstruction reinforced the fact that the intruder on March 6th intended not to murder Mackenzie Brackman, but to burglarize his home. The prosecution agrees that Mr. Becker is not so foolish as to premeditate this murder. However, Mr. Brackman did die as a result, a direct result, of Mr. Becker's attempted burglary. This constitutes felony murder. This is why Mr. Becker is guilty today. At the same time, Detective Jordan Markowitz, with her long years of experience and her specialty in cellular forensics, established another vital link. The phone of Avery Becker traveled directly from his own home to the home of Mr. Brackman, where it remained for an extended period as Avery Becker committed the crime. This is the same phone which Avery Becker is never without, the same treasured item that he carries day to day and can only use outside the house, not the sort of thing to lose. This phone traces Avery Becker's guilt. Now, Blair Rollins stands as the defense's feeble attempt to create an alternate suspect. This requires ridiculous contortions and depends on a series of perfectly random connections and events which ultimately defy belief. At the same time, the very idea of the stolen phone is a flawed fantasy. You don't use texts to search for a phone. They don't cause a ringtone. They're not helpful. And yet, of the 5 messages that Mr. Becker's phone received that day, 3, more than half, were texts. Those messages were not 2 friends seeking a lost item. Members of the jury, Mr. Becker's trend of avoiding consequence cannot be allowed to continue. Again, the consequences today are demanded by the law. The prosecution has brought a solid case entrenched in evidence which the defense can refute only imperfectly. There is no room today for reasonable doubt. For that reason, it is your duty to find Avery Becker guilty of second-degree burglary and the first-degree felony murder of Mackenzie Brackman.
All right, thank you, Counselor. And from the defense, any closing argument?
Yes, Your Honor.
All right, go ahead.
Thank you. No face, no case. Ladies and gentlemen of the jury, today you must decide if the prosecution has proved beyond reasonable doubt that Avery Becker, a high school student only connected to the victim through mock trial, committed the heinous crimes of murder in the first degree and second degree burglary of a dwelling. The prosecution must provide solid evidence of the location, offenses, venues, identification, and date and time of the case. The prosecution must show and prove all of these and for you to find Avery Becker guilty. And the prosecution cannot even identify Avery at the scene of the crime. No face, no case. The prosecution's witnesses consist of a civilian police employee for the police department, Kyle Kuzak, who processed the scene after others had already processed it and read reports to come to his conclusions, which he himself said could never give the full picture of a case. He also read reports from the prosecution's other witness, Detective Markowitz, who even after roughly 13 years of experience, lost evidence from the scene of the crime. Markowitz also didn't even look into the possibility of other suspects. He did his investigation with Avery in mind as the only suspect, completely disregarding a very reasonable suspect with a motive far more likely than Avery's. Blair Rollins was a mock trial student, and her motive is far more likely due to her father being sentenced to life in prison due to the victim, Mr. Brackman, losing the case. Blair's father was even recorded in court saying he would get the victim back if it was the last thing he did. Blair Rollins would not be a surprising suspect in this case, but the failure of the detective to look further into Blair goes to show the lack of police work and justice put into this investigation. And the prosecution's last witness, Alexey Fuentes, was said to be close friends with Blair and was there the night Avery Becker's phone went missing. Alex had everything to gain from the permanent removal of Avery Becker. Now, the defense today has shown you 3 witnesses. The first is Taylor Perkins, a close friend of Avery Becker's who was there with Avery the day of the crime and testifies that there is no way Avery could have committed it because they were with each other during the time of the crime. Next, we have Professor Van Owen. He has testified to believing that the investigation conducted by the prosecution's Detective Markowitz was rushed. Van Owen also testifies to seeing pictures of Avery and Blair and saying that they are of the same height and build. All of this is coming from not only a private investigator, but a professor and an expert in police practices. And last, we have Avery Becker himself, the suspect in a case where others weren't even looked into, a suspect in a case where you cannot even see his face. No face, no case. Avery was not the perfect student, but he is sorrowful and regretful for his past with Mr. Brackman. Being late does not create a murderer. A mock trial dispute does not create a murderer. The prosecution has tried to place him at the scene with a phone not even in his possession. There is a difference between a marker and a knife. I urge you to ask yourself if it is just to convict Avery Becker on the counts of murder in first degree and second degree burglary of a dwelling, when there is no true evidence or DNA placing him at the scene. No face, no case.
All right, thank you, Counselor. And from the prosecution, I show that you have approximately 14 or 15 seconds left for rebuttal. Go ahead and proceed if you'd like to take advantage of that.
Thank you, Your Honor. Ultimately, the evidence is sufficient. No face is needed today. Find Mr. Avery Becker guilty.
All right, thank you, Counselor. All right, these proceedings are concluded for today. All right, thank you to the teams on both sides. I want to just express just a few things here briefly. I always enjoy and look forward to this time of the year when we're doing the mock trial competitions. I'm always very happy to see just how much work and dedication and just how talented the teams are. I was really impressed today. I'm always continually impressed at the quality of these competitions and just how hard you all work. So I just did want to express my admiration to you all of what a great job that you did today. I know that some of you probably, I would imagine, I will see appearing before me as attorneys sometime in the not too distant future. And I genuinely look forward to that day when it happens. Thank you all for the hard work that you've put in. And then